Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. I also hope you're staying hydrated because it's hot everywhere. All right. Yes. This is going to be an update on what Boone has been up to in Lowell Annex. And I can say officially, she's got me saying, my, my, my. Ma. She ain't got no act right in her, right? So she had a disciplinary report. I can't tell if this is the same one we saw before because it was heavily redacted. This one is also related to lying if it's not the same one, but we have all of the details. And interestingly, it's related to her family court, the pretrial conference on 5/29. We also have some visitor updates. There's a couple things I want to point out to you. And then she's also having problems getting evidence for her family court. So let's get into it. First, I want to thank the members. I want to thank you too for being here. If you enjoy the video, please remember to give it a thumbs up. And if you're not subscribed, hit that subscribe button. Come hang out with us. But I will run the intro and I will catch you on the other side. All right, that may have came in hot. I did not lower it because I was hanging out with the sugar bear here. Let's get right into it, though, without further ado. Okay, disciplinary report. It was dated 6/5. We're going to start at the end. The summary. Inmate, her plea was not guilty. Sugar bear. Yeah. She pled not guilty. She was found guilty. Basis for the decision. The team considered all available evidence in rendering a decision to include reading all witness statements and testimony in addition to reports by officers. Inmate was afforded the right to make a statement in which she stated, I wrote a statement. This was a complete misunderstanding. Per classification officer F. Bonham Walker, inmate Boone, Sarah, stated to sentence technician A. Sims that she was given permission to bring her tablet to a legal call. Inmate was sentenced to 30 days canteen suspension from 6/5 to 7/4/2025. Inmate was advised she has 15 days to appeal the team's decision. So cashless canteen, 30 days. So no Zuzus and Wham Whams for her, at least that she can buy. I guess other people can give them to her. I'm not sure. Comments. The imposition of additional suspension of privileges and penalties was made to reinforce positive principles that could impact the inmate's overt behavior and thinking, as in it might help her get some act right installed. In this particular case, the inmate stated she was given permission by classification officer Bonham Walker to bring her tablet to a legal call when she, in fact, did not have permission. Inmate was sentenced to 30 days canteen suspension. Appropriate offices notified by DR log being sent out to administrative staff and the property sergeant and officer. So then we get into the background of how we got here, how she was charged. And you'll note this is on 5/31. The date of the infraction is 5/29, which was her pretrial conference. So, statement of facts. Inmate Boone is being charged with 910 lying to staff member or others in official capacity or falsifying records. On May 29, 2025, at approximately 10:29 hours, while assigned as classification officer at Lowell Correctional Institution Annex, while present in classification, I was approached by correctional sentence technician A. Simmons, who informed me that inmate Boone, Sarah, was attempting to bring her tablet with her into her telephonic legal hearing and had informed Miss Sims that I had given her permission to do so. At no time did I give the inmate permission to bring her tablet to classification. Inmate Boone remains in general pop pending the disposition of this report. Inmate notification of charges, date delivered 5/31/29. So 2 days after. No hearing shall commence prior to 24 hours of delivery of charges. So her charges were delivered on 5/31, so 6/2 is the earliest, I guess. 6/2 after 11:15. 6/2 being June 2nd, not the time. Except when the inmate's release does not allow time for such notice, or the inmate waives the 24 hours. As an inmate notice to inmate, as an inmate being charged with the violation of the rules of prohibited conduct, you are advised the following. Investigation. An impartial investigation will be conducted on this disciplinary report. During the investigation of the disciplinary report, you will be advised of the charges against you, and you may request staff assistance. During the investigation, you should make known any witnesses to the investigating officer. The testimony of witnesses shall be presented by written statements. See Rule 33. For complete information regarding witnesses, you will have the opportunity to make a statement in writing regarding the charge and to provide information relating to the investigation. Okay. Delivery. Ouch. Your little knee is hurting my thigh. A copy of the charges will be provided. We went over that. So the decision will be made in advance whether the hearing will be conducted by the disciplinary team or the hearing officer. So we know, because we already read it, it was done by the team. You may request a hearing by the full disciplinary team rather than the hearing officer. You will appear in person before the disciplinary team/hearing officer unless you waive this appearance by signing a waiver form. So I like that it's a hearing and it's fully documented. So, like, theoretically, there couldn't be one correctional officer who's like out to get you, who can just kind of railroad you, because this seems like you got to collect all the information. You have your witnesses, you make your statement, you get to choose if you want an officer or a team to decide. I like this. Okay, the chairperson hearing officer will read the statement and ask you for your plea. A guilty plea requires no further statement. However, you may make a statement for the team/hearing officer to enter a plea. Oh my goodness. You may make a statement. This type font. You may make a statement for them to consider. A no contest plea will be treated as a guilty plea. A refusal to enter a plea will be treated as a not guilty plea. If you enter a not guilty plea, you will be allowed to make a statement on your own behalf, present evidence, and request staff or inmate witnesses as deemed appropriate by the team/hearing officer. After the team/hearing officer has made a decision, you will be advised verbally and in writing, so you won't get confused, Boone, as to the decision and the evidence relied upon in making that decision. If you are found guilty, you will be advised verbally and in writing as to the recommended penalty. Appeal. If you are found guilty, you may appeal this decision by filing a formal grievance with the warden of your facility within 15 days of the receipt of written notice of the team/hearing officer's decision. For information regarding the rules on discipline, refer to 33-601. So then there's these workups. Basically, it just kind of recaps that. Lying to staff members, it gives a little more detail. On May 29th at approximately 10:29 hours, While assigned as classification officer, I was approached by correctional sentence tech A. Simmons, who informed me that inmate Boone Sarah, was attempting to bring her tablet with her into her telephonic legal hearing and had informed Miss Sims that I had given her permission to do so. At no time did I give the inmate permission to bring her tablet to classification. Inmate Boone remains in Gen Pop pending the disposition. She was like, girl, keep my name out your mouth. I ain't said nothing. What does CLO stand for? What did she say? Classification officer. Okay. Well, there you go. So she signs at 5:29. I mean, they're doing it the day of. Lickety split. So the report was written at 2:01 on the date of the incident. Review of disciplinary report approved. That was at 2:46 on the 29th. They're making quick work of it. Okay, here we go. So, disciplinary investigative report. This is at 2:20. Inmate declined staff assistance. Inmate Boone stated she misunderstood if she could have her tablet. She said that at 11:15 a.m. Classification Bonham Walker said at no time did I give the inmate permission to bring her tablet. CST Sims stated inmate Boone said that this officer did. Other inmate interviews, none. All forms complete. There will be no delays in this investigation. Other evidence, none. Notice to inmate, the following shall be read to the charged inmate by the investigating officer. And this again is written the same day. The hearing date is 6/5. The charged inmate shall indicate whether he has any material witnesses. In the event that you have material witnesses, they must be listed below. Failure to complete and sign section 2 of this form will result in a waiver of the opportunity to call witnesses either live or by written statement. As a rule, the testimony of inmate witnesses will be presented by written statements instead of witnesses appearing at the hearing. Multiple disciplinary hearings are often held at one time, and limited staffing prohibits the routine retrieval and escort of inmate witnesses to the hearing and back to assignments. Further, written statements minimize the disruption of work and program assignments of inmate witnesses. A request for live testimony for witnesses not listed below must be made at the hearing and supported by cause sufficient to overcome the concerns above. So that makes sense, because then people could be staging a coup by actually doing something wrong to get a hearing and then call like 5 of their homegirls to be witnesses, and it could be a setup. So lying to staff, that was the other officer. I know nothing about this. Ruth Ann Foss. So here's Sarah's statement. It was my complete misunderstanding I could bring my tablet to my legal call, which had most of my documents I needed for. After speaking to Ms. Santiago about everything regarding my family law case, Ms. Foss, and trying to speak to the warden in trying to receive physical documents to not use my tablet, in all the emails, phone calls, and messages in Rex, I misunderstood I could use after meeting with Ms. Santiago and discussing my options to be successful in my case, in my calls and case. We talked about many things where she was extremely helpful, and I did not understand about this. I would never disobey any rules of DOC or take advantage of the classifications department with ongoing, very needed help. I would never. Please allow me also to speak at my hearing. I apologize. And that was 5:31. Now, there was no mention of Santiago in these other witness statements. It was Foss and somebody hyphenated. So, ma'am, when you say someone gave you permission, that's not a misunderstanding. Like, now you're making it sound like there was a bunch of conversations and you got confused. Now we have Alana Simmons, a correctional sentence technician. Her statement when I asked inmate Boone who told her she could bring her tablet to her legal call, she, inmate Boone, stated that classification officer Bonham Walker gave her permission. So it's obvious, it's an obvious lie. No mention of Santiago. Which isn't that the name of the guy from A Few Good Men? You can't handle the truth. Did you give the order about Santiago? You're damn right I did. You want the truth? You can't. Okay, you get it. Then we go to visitation forms. This is Brenda LaFontaine. This is the woman, elderly woman, 58. Or I guess that's not elderly. I'm 54. This is the couple that had her, they had adopted her dogs. Other is listed as that. This was submitted in February, approved in March. Brenda, all this was clean. No criminal history, upstanding citizen. And then this is her husband, who's 61. And yeah. All this is cleared. And he's approved for visiting. You also need to do the visitor approval to submit money. I was wondering maybe that's why Brian doesn't finish his. Well, he probably doesn't want to go, number one, but also he can't be compelled to send her money because he hasn't met the criteria in order to be eligible to send money. We've got Nicole. She was approved in April. And they finally sent me the updated approved application that Peter submitted. And here's what I was saying before. He doesn't list a place of employment and he's approved. So when Sarah's saying to the family court, oh, Brian won't fill his out because he doesn't want to put his employment and perjure himself and the address and phone number, it's a lie. So there you go. So here he updates and corrects that he has been arrested or received a criminal citation, and he puts 9918 DUI. Mama. Thank you for the kisses. And then down here, have your visitation privileges ever been denied, suspended, or terminated? Yes, I made a mistake on the form about past criminal history. So he didn't lie. He also was mistaken, which is what Sarah's story was in her disciplinary action. Where did you meet this inmate? Pen pal. And then that was submitted on 4/29, right? The first one that was denied was submitted in February. And then he writes a letter to Alana Sims, who we know from the disciplinary action. Hello. I recently was denied for my application to visit Sarah Boone, an inmate at Lowell. At least he didn't put Booner this time. I am not sure why, but I noticed that the letter I received had my name spelled incorrectly. Also, when I reviewed the application and my answers, I realized I made a mistake. The question asked was about my criminal history, and I thought it was asking if I had to go to court for the inmate's case, not mine. I revised it, and please find it attached here. Sorry for the confusion and mistake. Please let me know next steps, Peter Gumthel. So let's see. I thought it was asking if I had to go to court for the inmate's case, not mine. Okay, let's see. What is the question? Have you ever been background is the section. Have you ever been arrested or received a criminal citation or a notice to appear in court to respond to criminal charges? So he thought it's asking if he received a notice to appear for Sarah's criminal charges. Okay, so what about, have you ever been arrested or received a criminal citation? That part, you thought that was related to Sarah too? Okay, sure. And then here's a printout. This is having to do with when he referencing the previous application when he was denied. So this was done by Jessica Harvey. Relation is personal friend, and answered no to number 10, has DWI in New York, 9/9/2018. So they got over that little hurdle and he was approved. So here in the background check, he gets an okay. And that's on 6/2/25. Then we have Danielle Parsons, who we saw in the text messages. She was submitted and approved. Her relationship or how they met is other. No criminal history. All is well there. Danielle Parsons has had visitation privileges approved, and she's also approved to send Sarah money. Okay, now we have Ms. Santiago about a different issue, but this is the woman who's been very helpful to Sarah. Much needed, is what Sarah said. Hello, per your instruction. Oh, and look, Sarah's job assignment is houseman as of 6/6. Okay. Hello, per your instruction from my in rec. That's the second time she says it. I don't know what that means. This is from 5/29, so the day of her pretrial conference, regarding my USB containing my family law case documents that were delivered 5/24/25. I am requesting access, please, and permission to view and utilize. I also sent requests to AWP, so I can do so ASAP, please. Thank you. Approved, must be stored in property. Copy the mailroom and property. And I don't know if that's the same person. That looks like something Quinn. So that was approved. And then we just have good old Sarah. We do see related visitors. Her son, oh, I forgot to redact his name, but her son is on here. Info only for visitor status, along with Lana. Oh, poor Lana. I don't know if they're going to remove her. And then all these other folks are on there as approved, except her parents, of course. So in this one, we see Peter as approved. The last time we looked at that doc, he was not approved. So that is it. Sarah's up to her old tricks in there, trying to smooth talk people, double talk, trying to get her files. She wants the hard copies again. She's got a USB. Same old Sarah. New day, same old Sarah. I have her phone calls, but I'll do them in a separate one because there's a lot of them, and I wanted to get this video out tonight while I'm up for it. It takes a lot of research to look up the numbers. Like, I have some of them, but I have to go back and look at the unredacted version to compare it. And so that's more work than I have the energy for, but I will get them to you. I promise. Let me know what you think. Busted lying. I wonder if that can be entered in family court. Take a look at her disciplinary records. Like, how's that appeal going, girl? How's your behavior going? Have you learned your lesson? Learning to be contrite? Are you yet sorry for taking George's life? Like, can you at least acknowledge that? Or are you playing that I'm waiting on my appeal game? Girl, you already said on the record you did it. So you can't take that back. You already changed your story once. You're going to change it again? All right, lovelies. I'll talk to you in the comments. Toodles.